The probate clerk sitting in the well of courtroom 3 that Wednesday afternoon, a calm, methodical woman named Doris who had docketed wills and contests in this building for 19 years, and who in those 19 years had quietly watched a great many families come apart at this rail, could tell, by the way the three siblings on the contestants' side of the table arranged themselves before the hearing was called, that they had been coached. They had been coached on where to sit. They had been coached on what to wear. They had been coached, by the lead contesting attorney at the end of their row, on what to say. The thing they had not, in any meeting at any law office in any of the last 6 months, been coached on, Doris knew, because she had carried the file from the docket office that morning and had, while she was carrying it, looked at the index, was that the file contained 23 voicemails. The voicemails had been preserved by the local trust officer at the request of the testator over the last 4 years of her life. The testator had been very specific in writing that the voicemails were to be played in any contest. The voicemails ran, all told, just under 11 minutes, and the contestants, the three estranged siblings sitting straight-backed in matching dark wool, had not in their entire 6-month preparation been told they existed. The testator's name was Mrs. Ruth Valancourt. She had passed in March at the age of 88 after 11 years of advancing illness. She had been married for 55 years to a printer named Henry Valancourt who had died in 2010, and she had borne and raised, between 1963 and 1975, 4 children, 3 sons, 1 daughter. The 3 sons had moved in their 20s to other cities. The daughter, the youngest of the 4, had stayed. The daughter's name was Claire Valancourt. She was now 61. She had not married. She had worked for 33 years as a part-time bookkeeper at the small parish school her mother had taught reading at in the 1970s. She had lived for the last 11 years in the small back bedroom of her mother's small brick house on the north end. She had in those 11 years made breakfast at 6 and lunch at noon and dinner at 5:30. She had bathed her mother on Mondays, Wednesdays, and Fridays. She had taken her mother, for the better part of 3 of those 11 years, to 26 different medical appointments. She had refilled her mother's prescriptions every 2 weeks at the same pharmacy on Bassett Street. She had read the local paper to her mother every morning after breakfast and the Daily Missal every evening before bed. She had, when the 3 brothers had come at Christmas in 2023, set the table for 7, served and cleared. She had, when the 3 brothers had not come at Christmas in 2024, set the table for 2. The 3 brothers, Mark, Etienne, and Gilbert, were now 64, 62, and 57. Mark, the oldest, was a regional sales director for a packaging concern in another state. Etienne, the middle, ran a small architectural firm in a city 300 miles south. Gilbert, the youngest brother and the second youngest of the 4 children, was a senior pension administrator in a city east. All 3 had, in the last decade of their mother's life, visited her on average twice a year, called her on average once a month, and contributed, between the 3 of them, nothing measurable to her care. Their mother's will, properly drafted, properly witnessed, properly notarized in 2020 by the local estate attorney their father Henry had used since 1976, left the small brick house on the north end, the modest savings, the modest pension survivorship, and the small antique clock that had hung in the kitchen since 1964 to Claire. It left, to each of the 3 brothers, $1,000 and a personal letter their mother had written by hand the same week she had executed the will. The 3 brothers had filed, in late April, a will contest. The contest alleged undue influence. It alleged that Claire had, over the 11 years of caregiving, isolated their mother from her other children, controlled her communications, manipulated her medication schedule, and coerced her into a will the contestants claimed she would not, in her right mind, have signed. The contest had requested invalidation of the 2020 will and reversion to a 2014 will under which the estate would have been divided in equal quarters. Sitting in the front row behind Claire that Wednesday afternoon, on the daughter's side of the courtroom, were 6 people. Claire's parish priest, who had visited Mrs. Valancourt at the house every other Friday for the last 6 years. The pharmacist from the Bassett Street Pharmacy, a soft-spoken man named Mr. Brody who had refilled the prescriptions and who had every 2 weeks for the last several years called Claire to confirm the pickup. The bookkeeper from the parish school, who had worked at the same office table beside Claire since 1993. A neighbor across the lane, a retired nurse who had checked in on Mrs. Valancourt on Saturday afternoons for 3 years when Claire had needed to do groceries. The visiting hospice nurse who had attended the family at the end. And a young woman in her 20s, a graduate student at the state nursing school, who had been one of the 4 part-time assistants Claire had hired during the last 6 months of her mother's life, and whom Mrs. Valancourt had asked, by name, about her studies every time she had come. Claire's attorney was a woman named Maeve Hennessy. She had practiced trust and estate law for 26 years. She had buried the year before her own mother after a long illness. She had taken Claire's case in May after Doris, the probate clerk, had quietly mentioned in the hallway one Tuesday morning that the file looked like one of the ones a good lawyer should look at. Maeve had spent the summer reading the file. She had spent September preparing. Judge Lynn Halverson took the bench at 2 precisely. She was 58. She had been on the probate bench for 12 years and on the family bench for 6 years before that. She had a soft voice and a careful, unornamented robe, and in her decade on the probate bench, had become the kind of judge that estate attorneys requested by name when their case involved a devoted caregiver they could not, in good conscience, allow to be rolled over by paper. "This is the matter of the estate of Ruth Genevieve Vaillancourt, deceased," Judge Halverson said. "We are here on the contest of the 2020 will filed by Mark, Etienne, and Gilbert Vaillancourt. The contestants are represented by Mr. Aubrey. The proponent is Ms. Claire Vaillancourt, represented by Ms. Hennessy. Mr. Aubrey." "You may proceed." Mr. Aubrey was 60, well-dressed and confident. He had specialized for 18 years in will contests. He had won by his own quiet count more than he had lost. He stood and gave a 20-minute opening that hit in the smooth, practiced order every undue influence buzzword in the bar's continuing education materials. He spoke of isolation. He spoke of control. He spoke of dependency. He spoke of the suspicious circumstance of a sole caregiver inheriting the family home. He gestured at 4 different points in the opening at Claire Vaillancourt, who sat with her hands folded on the table and did not, at any of those 4 points, look up. Mark, the oldest brother, took the stand first. He was, on direct examination, polished and quietly emotional. He testified that his mother had been a different person in her last decade. He testified that calls to the house had often been answered by Claire. He testified that he had felt increasingly that he could not get through to his mother. He testified that on the rare occasions when he had seen his mother in those years, she had seemed muted in his sister's presence. He testified that the 2020 will did not reflect the woman he had grown up with. Etienne took the stand second. He repeated in slightly different words the same testimony. So did Gilbert. All 3 were composed. All 3 were credible. All 3 had, Doris the probate clerk would later note in the running journal she kept in her bottom desk drawer, been carefully and competently coached. Maeve Hennessy cross-examined Mark for 9 minutes. She asked him to confirm how many times he had visited his mother at the house in 2023. He confirmed twice. She asked how many times in 2024. He confirmed once. She asked when in the last 12 months of his mother's life he had personally bathed her. He had not. She asked when in the last 12 months of his mother's life he had personally refilled her medication. He had not. She asked when he had taken her to a medical appointment. He had not. She asked how many of his mother's 26 medical appointments in that period he had been present for. None. She asked whether in 2023 his mother had been able to read the daily missal alone. He said he didn't know. She asked whether in 2024 his mother had been able to dress herself in the morning. He said he didn't know. She cross-examined Etienne and Gilbert in the same patient, careful order. Their answers were the same. Their patient inability to answer was the same. Then she called Mr. Brody, the pharmacist. Mr. Brody confirmed that he had refilled Mrs. Vaillancourt 6 medications, every 2 weeks, with Claire as the personal caller for the last 7 years of his pharmacy's record. He confirmed that Claire had never missed a refill. He confirmed that he had personally spoken to Mrs. Vaillancourt during a number of those refill calls, and that Mrs. Vaillancourt had, in his pharmacist's judgment, been competent, oriented, and her own person throughout. He confirmed that he had never, at any time, heard or observed Claire interfere with her mother's words or judgment. Maeve called the visiting hospice nurse, who confirmed the same about the last 6 months. Maeve called the parish priest, who confirmed the same about the last 6 years. Maeve called the neighbor across the lane, who confirmed the same about the last 3 years. Maeve called the parish school bookkeeper, who confirmed that Claire had, for the better part of 2 decades, simply quietly and without complaint, been doing the work. Maeve called the young graduate student, who confirmed that Mrs. Vaillancourt had asked her by name about her studies, and that Mrs. Vaillancourt had, on more than one occasion in the last months, asked the student to please make sure her daughter Claire took a proper lunch. It was by then 3:20. The contestant's attorney, Mr. Aubrey, had cross-examined gently and briefly. The contestant's 3 brothers at the contestant's table had not, by then, looked at their sister Claire for nearly 2 hours. Maeve Hennessy said, "Your Honor, the defense moves the court to receive into evidence the audio file marked Proponent's Exhibit 12. The exhibit consists of 23 voicemails left by the late Ruth Vaillancourt for the trust officer at her local trust company between June 2021 and February 2025, preserved at the testator's express written direction in connection with the execution of the 2020 will, and certified by the trust officer in the affidavit filed as Proponent's Exhibit 11. The voicemails run a total of 10 minutes and 48 seconds. The defense requests that the court play the exhibit in its entirety on the record. Mr. Aubrey rose. He began to object. He invoked relevance. He invoked the hearsay rule. He invoked with practiced ease the dignity of the testator. He spoke for nearly a minute. Judge Halverson listened without interrupting. When he had finished, she nodded. Mr. Aubrey, the voicemails fall squarely within the testamentary statement exception and were preserved at the testator's own written direction precisely for use in proceedings of this kind. The trust officer's affidavit authenticates them. The objection is overruled. Ms. Hennessy, you may play the exhibit. Maeve crossed to the AV cart at the side of the courtroom, connected her laptop to the cart's small speaker system, and pressed play. The voicemails played in chronological order as the date stamped them. The first was from June 2021. Mrs. Vaillancourt's voice was clear, careful, unrushed. This is Ruth Vaillancourt calling for Mr. Pelletier at the trust office. I would like to confirm the file you have for my will. The will signed in June of last year is the one I want. Please call my daughter Claire if you need me. Thank you. The second was from October 2021. The voice was the same. This is Ruth Vaillancourt calling. Please make a note in the file. My daughter Claire is making my breakfast and my lunch every day. She drives me to my appointments. She has not at any time asked me to change my will. I want this in the file. Thank you. The voicemails went on. They were short. They were dated. They were unhurried. They did not in any of the 23 raise their voice. The voice of Ruth Vaillancourt the room could hear was the voice of a woman who had lived a long, careful life and who had decided at the end of it to make the record straight. The 14th voicemail was from August 2023. It said, Mr. Pelletier, I'm calling on a Saturday. Please excuse the time. My oldest son Mark called me last evening. He told me that I should think very hard about my will. He said that Claire was, in his words, taking advantage of my condition. I would like the file to reflect the following. My daughter Claire has, every day for the last 8 years, made my meals and given me my dignity. My son Mark has, in the last 8 years, visited me on average twice a year. I am of sound mind. I am not under any influence other than the influence of my own daughter's kindness. Please put this in the file. Thank you. In the contestants' row at that voicemail, Mark Vaillancourt closed his eyes. He did not open them again for nearly a minute. 16th voicemail was from December 2023. It said, Mr. Pelletier, my middle son Etienne called yesterday. He asked me whether I had considered, given my failing health, simplifying the will. I told him that the will was already very simple. He said that what he meant was that perhaps the will could be divided in equal quarters. I told him that the will was as I had directed it. I would like the file to reflect that Etienne called me and that I gave him this answer. Thank you. The 19th voicemail was from June 2024. Mr. Pelletier, my youngest son Gilbert came to the house yesterday. He brought a small gift. He spoke at length about pensions and about the importance, as he put it, of orderly transition. He suggested that I sign a document he had brought with him. I declined. I told him that any change to my will would go through Mr. Tessier, our family's estate attorney since 1976. He left the document on the kitchen table. I have given it to Mr. Tessier. Mr. Tessier has filed it with the court's records office. Thank you. The 23rd and last voicemail was from February 2025, 4 weeks before her passing. The voice was thinner. It was still her voice. Mr. Pelletier, this is Ruth Vaillancourt. I am calling finally to say what I have wanted on the file for a long time. My daughter Claire has stayed. My 3 sons have left. I love my 3 sons. I have written each of them a letter. I have left each of them a small gift. I have left the house to Claire because Claire lives in the house. I have left my care to Claire because Claire has cared for me. I am of sound mind. I have signed the will I wanted to sign. I would like the record to be clear. Thank you, Mr. Pelletier. Goodbye. The last voicemail ended. The courtroom held very still. The probate clerk Doris, in the well of the court, made one small note in the docket. 2323 played 1437. Judge Halverson set down her pen. She looked at the contestants' table. She did not look long. She turned to her own page. On the record before the court, Judge Halverson said, the proponent has authenticated and submitted 23 contemporaneous statements by the testator, made over a 3-year period before her passing, at her own written direction, preserved in the file of her trust officer. The statements directly and conclusively rebut the contention of undue influence. The court further notes that the contestants have presented no documentary evidence of any kind to support the contention of undue influence, and that on cross-examination, none of the three contestants was able to identify a single act of caregiving they had performed for their mother in the last 12 months of her life. The court finds that the 2020 will is valid. The contest is dismissed. The will is admitted to probate. She turned the page. The court further finds on the record that the contest was filed without substantial basis in fact or law. The court will, by separate written order, refer the conduct of the contest to the disciplinary committee of the State Bar for review of the lead contesting attorney's preparation of the petition. The court will further refer the contest, as a probable frivolous filing within the meaning of the probate code, to the Office of the Public Guardian for review and to the Office of the State Attorney General for any pattern of conduct review. Mr. Aubrey, you will be required to file a separate written statement of the work product underlying the contest within 30 days. Ms. Hennessy. The proponent's reasonable attorney's fees, costs, and disbursements in this matter will be taxed against the contestants pursuant to the probate code's frivolous contest provision. She paused, she looked again at the contestants, then she looked at Claire. Ms. Valencourt, Judge Halverson said, the court owes you no apology. The court is not the one who owed you one. The court will, however, on the record say two things. The first is thank you. Thank you for 11 years of patient care for a woman this court did not know but feels after 14 minutes of her voice on the record that it has in some small way met. The second is this. Your mother's voice has been on the record now. The record will not lose it. The will is upheld. The house is yours. The clock in the kitchen is yours. Take her home. We are adjourned. Claire Valencourt did not weep. She did not stand. She nodded once to the bench. Then she turned her head very slowly and looked for the first time in 2 hours at her three brothers. She did not say anything. She did not have to. The voicemails had said it. The judge had said it. The record had said it. Mark, the oldest, looked at the table. Etienne looked at the wall. Gilbert covered his face with his hand. None of them, for a long minute, moved. In the front row, the parish priest leaned forward and set his hand, very gently, on Claire's shoulder. The pharmacist, Mr. Brodie, who had not, in 19 years of refilling prescriptions, ever been in a courtroom, lifted his hand to his eye and pressed there. The neighbor across the lane took a small handkerchief from her purse. The young graduate student, who had only known Mrs. Valencourt for the last 6 months but had been asked, by name, about her studies, took out her phone and very quietly sent a text to her own mother that read only, "I love you." In the well of the court, Doris the probate clerk made her last note in the docket. She had in 19 years kept the docket on every contest that had crossed her desk. She had quietly, in her bottom drawer, kept a running journal of the ones that had gone right. The journal had, that afternoon, become slightly longer. Outside Courtroom 3, on the wide marble corridor that ran the length of the second floor of the county courthouse, Claire Valencourt walked, with her parish priest on one side and Mr. Brodie the pharmacist on the other, slowly toward the elevators. The afternoon light from the tall west windows fell across the marble in long warm bars. Maeve Hennessy walked behind them, carrying both her own briefcase and Claire's small worn handbag because Claire had not, when she had stood, remembered to lift it. None of them on the long walk to the elevator said anything. The corridor was, for the moment, the right kind of silence. The building had done what the building had been built to do. The voicemails had done what their author had asked them to do. Ruth Valencourt had, in her own careful hand, kept the record straight. 3 months later, when the disciplinary committee's review of Mr. Aubrey's preparation of the petition was concluded, the lead contesting attorney would receive a formal letter of caution. The State Attorney General's office, in a separate review, would identify a pattern of similar weak contests filed by his office over the previous several years, and would, by the following spring, open a deeper review. The three brothers would, by autumn, pay the proponent's attorney's fees in installments their attorney would negotiate for them. The $1,000 bequest each had received under the 2020 will would, on the advice of Maeve Hennessy and with Claire's agreement, be paid out to them in full despite the contest. Claire would not in any of the subsequent years refuse her brother's calls. They would not in the first year call. They would in the second year begin to. The first call would be from Gilbert, who had covered his face. He would ask Claire whether the small antique clock in the kitchen was still keeping good time. Claire would say that it was. She would say that the clock had been wound every Sunday for as long as she could remember. There would be a silence on the line. Then Gilbert would say very quietly, "I was wrong," and Claire would say also very quietly, "I know." The clock in the kitchen on the north wall of the small brick house on the north end would go on keeping time. The pharmacist would go on refilling every 2 weeks for the next several years the medications of the next elderly client on his list. The parish priest would go on visiting every other Friday the next elderly congregant who needed a visit. The neighbor would go on checking on whichever neighbor needed checking on. The voicemails would remain in the file. The will would remain on the record. The dignity of one quiet life of caregiving, which had not in any of those 11 years been asked to be witnessed, had been witnessed in the end by a building. The building in its quiet and lawful way had received it. The record, which always in the end was the witness the room had needed, had carried it forward. It always in the end would.